Hi, I'm Rick Carver, and thanks for watching my story. Once again, thank you to Cecil County News as well. In the last segment, we detailed some of the mistakes Global Title recorded in the deed of trust for my loan in 2005. In fact, it is these recorded errors that ignited Kosogof to commit the crimes that he did. Global Title's egregious mistakes legally prevented the trustees for the bank from bringing any successful action against me and my family. This is the reason the bank's lawyers or trustees filed the $560,000 title insurance claim in the first place with Kosogof at Security Title. We provided the title insurance claim letter from the bank's lawyers to Kosogof. This insurance claim is why John Kosogof became involved. He researched the deed of trust and discovered all the mistakes that his agent company, Global Title, was responsible for, because Security Title is the underwriter for the insurance policy that Global wrote and sold to the Carvers, to my family, as part of the loan requirements. Kosogof had to decide how to proceed. He was faced with having to pay a legitimate $560,000 insurance claim to the bank. The bank's interest was the collateral for the loan, which was the 3.5-acre parcel and house. What I'm about to show you is John Kosogof's blueprint of how to plan and execute criminal fraud. Make no mistakes, the following facts and documents show you exactly what he did. White-collar crimes are created and executed with several built-in realities. First, the people who do the planning are normally devoid of any empathy or feeling as to who may get hurt within their criminal plan. Second, these people usually have in-depth experience in their field of business, so they naturally have the insight how to build layers and layers of convoluted and confusing references and even documents that are lies and fraudulent. I will prove this to you in a minute. Third, always 100% of the time, these criminal blueprints have additional well-thought-out planning regarding the what-ifs. For example, what if someone finds out the truth? Or what if any authorities are called in, etc. In other words, what the backup plan would be. This is where I have to really hand it to Kosogof and his lawyer, Dwight Tomey. This part of the blueprint was totally effective in trial. For sure, it was thought out and planned from the very beginning, and I think you will be impressed with how this multiple-layered crime was carried out. The first thing Kosogof had to consider is how to secure the bank's interest, which is the legitimate collateral. The recorded mistakes made by Global left the bank with no way to legally recover its collateral from the loan. So if Kosogof could figure out a way to resecure the dollar amount of the collateral that the bank held in its title insurance policy, well, bingo. Now, if you remember, back in 2005, the value of land was at an all-time high. The collateral from my loan was appraised from the bank at $720,000 and was for the house and 3.5-acre parcel. The insurance policy that the bank owns was for $560,000, which was the amount of the loan, and it's customary. This is very important to remember. A big hurdle for Kosogof to overcome was in 2010, when all this happened, land values were way down compared to way back in 2005 and the bank appraisal. So the bank's title insurance policy was actually worth much more than the current 2010 land value by a couple $100,000. Yes, folks, you heard me correctly. Kosogof really was in a pinch here. Would he pay out a legitimate title insurance claim that was worth much more than the current value of the listed collateral? That would leave his company still having to pay a lot of money. The answer to this is no, he wouldn't. What he did instead, Kosogof created a counterfeit deed of trust to replace the original. On the right, you're looking at the counterfeit deed of trust, and on the left is the original front page. These are the front pages only. Notice he added my wife's name. This would eliminate the problem that is called tenants by the entireties. Without my wife's name being added, no legal action by the bank could be successful to correct anything, simply because of the fact that my wife was not a listed borrower. If Kosogof attempted to negotiate any kind of new settlement with the Carvers, he would have to convince my wife to accept debt liability from a loan she never even signed and never was part of. Fat chance. So he added her name anyway to the deed of trust, as you see, and lied at trial by stating my wife was a borrower. Why would anyone ever sign a deed of trust for a loan when they never were a borrower to begin with? You are now looking at the fourth page of the counterfeit on the right and the original deed of trust on the left. The very first thing to observe is that Kosogof left the non-existent 41-acre parcel legal description in his counterfeit. So Kosogof never attempted to correct this error. If you look at the original deed of trust on the left, you see highlights center left side, being parcel 02039818, and under that it says total acreage 3.505. Now look to your right at the same area on the counterfeit. Notice the total acreage 3.505 is missing. Kosogof made sure to remove the total acreage in order to create an illusion that the parcel number that was left, that he left there, appears to be the parcel number to that non-existent 41-acre parcel. Folks, you are witnessing a crime right now. But wait, there's more. At the top of these pages is Security Titles Identification banner. Look close at the top left. It says Commitment for Title Insurance, Refinance Second. Yes, folks, Kosogof actually insured a non-existent parcel that was never the collateral in the first place. Hey, Maryland Insurance Administration, you guys paying attention to this? You guys see anything wrong here? Or is this your standard? Is this the standard operating procedure for all insurance professionals that are licensed through you guys? Next up, Kosogof added 2 additional parcels. Page 5 is the 6-acre parcel, and page 7 is the 50-acre parcel of the land I owned. By recording these additional parcels, Kosogof achieved 2 separate things, which were part of this criminal blueprint. First of all, citizens incorrectly had control of the lien for the 41-acre parcel. Kosogof erased the total acreage 3.50 from the original to give the appearance that the ID number that he left matched the ID number for the collateral that was listed in all the loan origination documents. In fact, that number is found in all land and tax records, and it goes to the 3.5-acre parcel, not 41. Second, Kosogof added and recorded those other 2 parcels within the same deed of trust that's under Citizens Bank's control. So now Citizens legally has the rights to all of my property and the value of all the combined parcels of land that far exceeds the value of the title insurance policy. You get it, folks? He figured out how to make sure the bank gets much more than its original security for the loan, and Kosogof is free and clear of having to pay the title insurance policy. Hold on, one more thing. Kosogof had to make sure that the clerks in the land records offices did not compare the original deed of trust to his counterfeit deed of trust. This is the land intake sheet that was attached to the original 2005 deed of trust. Notice the highlighted area. Look close at the property tax ID number. It is the same number that he left on the 41-acre legal description of his counterfeit. Remember, he removed the total acreage 3.505. Just in case someone in the records office looked closely at the 2 deeds of trust. The land intake lists the correct tax ID number for the original loan collateral, but Kosogof now has it fraudulently representing the non-existent 41 acres as the collateral. But just to be extra sure no one catches on to what he did, Kosogof illegally omitted this intake sheet altogether from his counterfeit recording. Hey folks, again, you are witnessing the execution of a criminal fraud. I know you are asking, how in the heck could Kosogof have been able to record his counterfeit? How did he get it to the counterfeit deed of trust that replaced an original? He had no authorization from the owners and never even gave notice. The answer is he committed additional crimes of criminal fraud. Folks, on the left is the original July 19th, 2010 request to record the counterfeit sent to the clerks at the Land Records Office. Take a look at that, folks. This is incredible. Kosogof ordered a subordinate employee to send this request who no longer works for him. On the right is the front page of the counterfeit that you may have already viewed. Please look at the request on the left in the highlighted area. See where it states enclosed is a check and an original deed of trust? See that right there? The request asks for this deed of trust to be re-recorded with corrections noted on page 1. I just showed you a couple minutes ago all the alterations and additions that John Kosogof made to the original deed of trust, which created his counterfeit. Clearly, what he wrote in his request to the clerks is a lie, created to deceive anyone who reads it, and instead convinces them into thinking there is an original deed of trust enclosed. But in fact, it's his counterfeit. Please look at the right. Kosogof stated that this deed of trust is being re-recorded to correct a scrivener's error in the name of the borrower and the legal description. This is a good one, folks. You're now looking at the state of Maryland's doctrine of scrivener's error law and legal definition. A scrivener's error correction is used when a typo has occurred. Something not big, guys. Something that's not that important. Look at the underlined section that states if such correction affects property rights, then it must be approved by those affected by it, such as the property owners. Of course, Kosogof never notified anyone. How could adding hundreds of thousands of dollars of land ever be considered a scrivener's error correction? Can you just imagine if everyone were allowed to use a scrivener's error correction the way that Kosogof did? Everyone who has a mortgage could just change their deeds of trust, removing whatever they wanted to. This is what Kosogof states in his testimony, as I will show you later. As you just saw, this is proof that all the changes and additions to my deed of trust could never be explained that Kosogof was simply utilizing a scrivener's correction. Wait till we bring you the trial testimony on this. Keep in mind that in his request, he never mentions to the recordation clerks that he is adding my wife's name and added hundreds of thousands of dollars worth of additional land, removed part of the legal identification of the real collateral, and omitted the land intake sheet. Never mentions those things. Those parcels Kosogof added now became more collateral for the loan. Yeah, these were all just corrections, all right. Kosogof also committed mail fraud, folks, plain and simple and by legal definition. He mailed the request and the counterfeit deed of trust. He used the U.S. Postal Service to perpetuate this criminal fraud or scam on the recording clerks. This is mail fraud. Well, Kosogof did plan perfectly. He figured out every last detail, didn't he? The perfect white-collar crime. But he missed something. Something he never should have allowed to have happened. This stopped his multiple layered crimes. Let me tell you something. Hey, State's Attorney James Delmeyer and Attorney General Frosch, you all paying attention to this? You should. Well, folks, I can't wait to bring you the next segment. Stay tuned, and thank you to Cecil County News for your unwavering support.